that wants to sell a house in LA she inherited from her dad. Should be simple, right? There's tenants involved. We got that handled, got it all figured out. But there's a problem. Dad didn't leave her house in a trust, didn't leave it in a will. He signed a quitclaim deed before he passed and put her on title. It felt smart. It avoided probate and those costs and time, but it gets better. Dad didn't buy that house either. He inherited it from another relative the same way, a quitclaim deed before that relative passed away. So now my client is sitting on a property that's gone through 2 generations of quitclaim deeds. And now that she wants to sell it, I have to give her the bad news that her cost basis is crazy low. It's what the original owner paid for the house decades ago. So in order to sell, if she doesn't do a 1031 exchange, she's looking at a $148,000 income tax bill based on this house. She didn't buy it. She just inherited it. Everybody in the family thought they were doing the smart thing twice. It's an easy mistake to make. I don't blame them. But if you own 1 or 2 rentals, basic estate planning works just fine. If you have a complex portfolio, that's what we're going to talk about tonight. Multiple properties, maybe some inherited across counties, bunch of different property types. The shortcuts that you're hearing online and maybe in AI that they're telling you to take, those are going to destroy generational wealth. So a quitclaim just before death, a will but no trust, a transfer on death deed, which I've had some clients who've done that as well, or just plain joint title with right of survivorship. These are sold as a way to avoid probate, but all 4 of them can cost your family more than a probate ever would. So tonight we're going to walk through each of these, why they feel right, but ultimately why they're wrong, and what you should be doing instead. And our guest, when I sent him the topic for tonight, he wrote back and said this hits home personally because his grandparents took a shortcut. It seemed smart at the time, but it ended up hurting the family. Michelle's in the background, keeping things clean, monitoring the chat. Drop your questions in. And remember, I can't give tax or legal advice. The guy who should be wearing a tie, he's wearing a jacket. I'll give him that. He can go ahead and give you some legal advice, but you got to book an appointment with him one-on-one. So we're going to bring in Kevin. He's an estate planning attorney, trust attorney, principal at Snyder Law, offices Irvine, Pasadena, Concord, and San Jose, BA from Boston College. This guy knows his stuff. JD from University of Richmond, LLM from California Western. He's been on the show before. He's going to be on the show again, and we're going to talk about big things tonight. But the most important thing about this guy is he's a good dad and a good husband. Bring him in, Kevin. Get in here. Welcome, my friend. Welcome.
What an intro.
Did you like that? It was, and the studio audience was so excited to have you here.
I felt a little bit like Rodney Dangerfield. I get no respect, I'm not wearing a tie.
Speaking of Rodney Dangerfield, back to school. I've been meaning to watch that movie with my kids. Anyway, we're old men, so that resonates for us. Especially, I picked up my son from college today. His first year is done at San Diego University. It's crazy.
Wow,
it flies by.
Wow. Congrats.
And you just had a big birthday in your house. What was the birthday you guys had?
We now have all teenagers. So my youngest turned 13 last month. So now it's a lot easier to say, I got teenagers as opposed to we have 2 teens and a 12-year-old who acts like a teen. But now they're all aged up to where they act. They're all teenagers. It's great.
It flies by. It flies by. And let's dive in and talk about your story, because I can't wait to hear this. And it maybe is partly the inspiration for the path that you ended up going down with your career. What is it that your grandparents did? What was the shortcut they tried to take with planning?
Similar to what you were just prefacing with your client, taking the shortcut of avoiding probate by adding children to title. Right? In this particular case, my grandparents had 3 daughters, one being my mom, and they were concerned about their home being lost to Medicaid should they go into a nursing home. Now, they lived in Connecticut. Rules in Connecticut for Medicaid are different than California, but conceptually the same. Like, hey, we're worried that should we go to a nursing home and the state pays for some or all of this, can the state come back and take our assets out of our estate so our kids get nothing? So that was their concern. And so what, I don't know exactly how they came to this conclusion, if they were advised or whatever, the advice from an actual lawyer or a neighbor, family friend, the scuttlebutt, hey, just do this, really easy. Probably that, because I see that. Like, hey, let's just do this. It's really easy. So what they did was they gifted their home to their three daughters, and they treated it like a pseudo life estate, but they didn't set it up like a legal life estate did, because their daughters weren't going to kick them out of the house. They were just going to change the deed, and they're going to live at their house. Everyone's going to consider it their house, and that's what happened, right? There was no issues there from that perspective, and they all recognized it that way. The proverbial crap hit the fan after they died. So my grandfather died, and then my grandmother lived another 10 years, no issues. She doesn't own the house she lives in, but that's not a problem because everyone gets along with mom. Mom passes away. Well, that's when things went south, because all three daughters owned the house. Guess what? They all had different views of what to do with the house.
And just to clarify, there was no documentation put into place at all to specify what was going to happen once parent.
Oh yeah, that's a good part. So there was no will, no trust.
Wow.
Nothing to dictate, because it was felt like, well, it's their house. They'll figure it out. They'll know what to do. They can figure it out. They can all work together to come to the right conclusion. And at the time that was done, my aunt wasn't living at the home. One of my aunts wasn't living at the home. And so, but by the time my grandmother died, she was living at home with my grandmother. And so we see this quite frequently for whatever reason, whether the adult child moves back to care for their parent or companionship, or maybe it's mutual, in the sense that maybe the adult child is disabled and that's why they're home. And whatever the reason is, that this is a common scenario. And that's where things went south is, well, that aunt wanted to live in the home. And this has been her home for many years. This is my home. And then another aunt wanted to sell the home. And then my mom wanted to sell the home too, but kind of was trying to be brokered the peace between the two of them, because one was they're on polar opposite ends. This is my house. You should just give me your shares because I lived here, help mom. You guys have homes. I don't. I moved back in here. We should just sell the house and split the proceeds. You can go get a place somewhere else with your inheritance. And so back and forth and went, and so it was a long time before they were able to figure out, get the house sold. So, eventually the house was sold. My aunt had to move out and move on with her life, but a lot of hurt feelings. And sadly, the coda on the story is fractured relationships for the rest of their lives. And so that from all the way down. So not just between sisters, between cousins, aunts and nieces and nephews. I mean, it was really caused a huge rift in the family as a result of these what had happened in there between, and that could have been avoided. I mean, best intentions, but it wasn't really thought through. So,
no, that's a great point too, that it ends up trickling down through the rest of the family. It's easy to forget it isn't just the most immediate generation. It could become Hatfields and McCoys type of thing, where it's for generations the family's upset. And then from a tax standpoint, by doing that, there was no step up in basis for income tax in that scenario as well.
That's right. So therefore, for my mom's share and one of the my aunt's shares, that's right. But the share, the 1/3, did get some tax relief on the capital gain because that was her primary residence. So that helped her, but didn't help to the others.
And that shows you how long it took, because she has to be living there 2 out of 5 years. So she may have had some pre-existing primary residence time there, but maybe not. So no, I appreciate that insight. And I want to dovetail into what happens when someone walks into your office and brings that up, that's their plan to avoid probate and avoid having to do a will and a trust for the real estate. Do people tell you that, or do you find out when you start diving in and looking at their portfolio that that's the plan?
Sometimes it's the latter. We talk it through. Oftentimes, those that just upfront honesty and questions about like, well, why do I need a trust? I literally had the conversation the other day with a couple, and they're both they're retired professionals, high acumen on things. Their professions that they had, they were involved in the law. One was a lawyer, one was in law enforcement, so they are surrounded by the law and everything. So they're not. They know what happens in court, how bad stories and things, and how things don't work out if you have to go to court. But be that as it may, the question comes, well, why do we need something more than just joint tenancy? We own the house together as joint husband and wife, joint tenants. Why would we need something else? And it was an earnest question, not from a standpoint of, we're cheapskates and I don't want to pay you any money, lawyer. It's more of an earnest question, like I don't understand. It seems pretty cut and dry. It's like a beneficiary designation. Why do we need anything other than a beneficiary designation? So that was a lead into that conversation. We're here to get advice because we're just confused. Everyone keeps telling us we need a trust, but I see it pretty clearly. We have everything owned and joint accounts, or have beneficiary designations, and we have joint tenancy in our house. What's wrong with that? So that there's that, and then there's sometimes it's what you said, like it's uncovering, like, all right, oh yeah, we don't have to worry about that property because I own it jointly with my brother. Don't worry about that. Or I own that with my mom. Don't worry about that. So that is very, very common.
Well, yeah, and let's flesh out the joint tenancy concept in case folks aren't quite familiar. What happens with joint tenancy is that husband and wife who hold property as joint tenants, in the event that one passes, the other spouse then they have full title to the home, doesn't need to go through probate, nothing special needs to happen. It just becomes theirs. They do get a step up in basis as well at that point in time. The disadvantage, and you're going to flesh it out even further than me, but one quick and obvious disadvantage is if there's kids involved and both of the parents pass, you haven't solved that piece of the puzzle at all with the joint tenancy. So flesh that out, please, Kevin,
Yeah.
why joint tenancy is not sufficient.
Yeah, it's called kicking the can down the road. So yeah, sure. If life goes sequentially, this is what I call a static solution. So we have a certain static chronology. We're saying if these events happen in this way, hey, joint tenancy could work. But life rarely happens in one modality. There's all sorts of contingencies. So, all right, well, let's think of a different contingency. You and your husband pass away close in time, or at the same time because you got in a car wreck and you both die in the car wreck. But what are the chances of that? Well, it does happen, and do you want to roll the dice on that? But also very common, particularly with older individuals, is one spouse passes away and the other one doesn't last very long, right? And they pass away, or it's an illness, a happenstance, and the person holding the title at that point, it's meaningless because they didn't have a chance to update it to add anybody else's joint tenants or put it in a trust. And so you just get benefit of one death in that scenario. So we don't want to leave life to chance because if we're talking about playing this out 10 times, one time out of the 10 times of our scenarios, it works. Last time I checked in baseball, if you went 1 for 9, you're riding pine. So I don't think that really works well.
Well said. Well said. Yeah, that's it. It may be a good stopgap while let's say because I just had this actually happen to some clients, first time home buyers, and we found a house. They loved it, got it into escrow, ended up being an all cash deal, very quick close because family was helping out. And they wanted to put it in a trust. But they still needed to create the trust. So thankfully it was done before the close of escrow and got to put it into the trust. But the joint tenancy would have been potentially a very short, few day stopgap in the event that they didn't have the trust set up.
Yeah, time. For sure. It's a good stopgap for that. Absolutely. So there are good purposes. I'm not going to say that you never would do it. If husband and wife are going to own the property, as a stopgap, though, for example, if it's a short period of time before a trust is created, we want it as husband and wife as community property with a right of survivorship.
Yeah.
and the reason has to do what you were referencing earlier with the step up in basis. With joint tenancy, the step up only occurs on the decedent's half,
Okay.
not the whole property. And it only works for married couples or those that are legally domestic partners. And I say legally, meaning that you have a document, a county document that says you are domestic partners, not, hey, we just refer to ourselves that way. So you have a marriage certificate or a certificate of domestic partnership. You get, you can be husband and wife or as domestic partners. And one of the domestic partners or the spouses dies, then there's a full step up on the property.
Yeah, and that's important. So the step up in basis, just to refresh for those listening, when you pass away and you've handled, you're using a trust, for example, the property will get a full step up in basis. So let's say whoever passed away bought it for 100,000, which at one point in time, homes did sell for less than 100,000 in California. That same home now may be selling for 1.1, so it's gone up $1 million. So with a step up in basis, a full step up in basis, when the person passing it on passes away, that home's value will now be set at 1.1, the current market value, and that will erase any potential capital gains at that point in time. How's that description? You like that?
Nailed it.
So it's what's interesting, and we'll move on, but the step up in basis, that is one of the questions I ask, and it's a personal question. Like, I'm asking sellers or property owners, hey, has anybody passed away that held title to the property? And maybe you got to step up in basis if it's a property that appears to show ownership a long time. And then the other side of it, not only is the step up in basis, we're trying to figure that out to try and figure out capital gains, so they have the right questions asked their CPA. We also need to make sure title was handled correctly, so we get a title officer involved. So when you're setting up trusts, that's, I'm assuming, part of what you have to do too, Kevin, is make sure that any previous transfers have been done correctly.
Yep, that's right. So that we do a quick and dirty title search. It's not, make clear, it's not, we don't substitute a policy. There's no title policy ensuring that there's no issues with the chain of title. And kind of fun little fact, we call that cloud on title. It sounds like, oh, cloud to be comfy and comfortable. No, like cloud you can't see. And so we can't really see it's cloudy and looking backwards on who owned what on the whole property. But we could get a quick and dirty and see sometimes if some of those errors are obvious.
Yeah.
And then we have to work with the title company to say, hey, how should we fix it? We would like to fix it this way, but would you guys accept that to issue a new policy? And that's where it's really helpful to have those relationships with title insurance companies, because then sometimes with lawyers, myself included, you get in your head like, well, legally we should do it this way, but the title company's like, oh, you don't have to go that deep. It's not that deep.
Yeah.
You could just do it this way, and we'd be totally cool with that and issue a policy. Great, it's an easier solution. But we do have to look at that, because common issues are names are misspelled, trust names are misspelled, people change names, but that was never documented, to property descriptions. There's errors in the property descriptions. So those are all like common things that, and every once in a blue moon, the error in the property descriptions, I've seen this, is that it's a description for an entirely different property. They got lost somewhere and it's the wrong one. And that, those are all things that are fixable, but it takes time. And if you don't catch it, all you're doing is perpetuating the problem.
Well, and I think it's funny you say cloud on title, and that's the official name. I don't think cloud actually gives it the justice that it's due. It's more like a hurricane or a tornado on title, because even those don't apply, because those tend to assume that they're going to pass at some point in time. Clouds don't disappear on title anyway. No. You have to actively work. And you're right, Kevin. It's funny because kind of a quick example. I had a property where two children inherited it from their parents through a trust, and that was like 10 or 15 years ago. And then they each put it in a new trust. And the title company at first was saying, hey, we need that old trust. But then they're like, well, I mean, it's not like there's any sort of scam going on. The kids waited 15 years to sell the property. So and there's more to it, but basically, like you said, talk to the title company and see what they say to do where they'll feel comfortable
Yeah,
and offer title insurance. Because at the end of the day, if a title company is willing to insure it, they'll defend the title to the property. They'll put their money on the line.
that's
So
exactly right. They're vouching. That's exactly what the
yeah,
policy.
perfect way to put it. So this was one we're still going through the shortcuts. So the first one was the quick claim. The next one is basically just having a will and not having a trust. And that would be because you can easily Google up a California standard will and fill that thing out. You get a witness or two and you're good to go. You think you're safe. But when I was surprised, this is part of why I have you come on my show. I didn't realize that did not avoid probate, actually put you into probate. So
Yeah,
tell me more
yeah.
on the
So there are
will, no
there
trust.
are these things called probate thresholds that in California this is only for California, right? So if you're listing and thinking about properties in other states, this does not apply. But your state does have similar types of rules. The thresholds are just going to be different. In California, the threshold for probate is fair market value aggregate, in the aggregate of all your assets. So not just one individual asset, all of them together. It's now $237,400. It just went up for April 1st, new law. So let's just call it 237,000. If your collective fair market value of your assets, not equity, and mortgage properties don't discount the debt. You count fair market value. If it's over that threshold, then you land in probate, even if there is a will. So the will is helpful from a standpoint. It instructs the probate judge who the executor is going to be and who the beneficiaries are going to be. So they don't have to go through this appointment process, finding people or finding heirs. It's all there and clear. But the process from a timeline perspective, same timeline, average 18 months, same cost of going through it. The statutory fees are the same as if there was no will. So the only thing you gain is an assurance of who the executor and the beneficiaries are. Maybe that avoids some sort of conflict potentially, but you can always do a will contest. So really, there's no extra value. Is the way I explain clients. It doesn't avoid court, so it doesn't avoid conflict, because conflict could always creep into court, and the cost and the time are the same. Because in Southern California, the value of our properties are through the roof, with one exception. New law is on a primary residence. So the primary residence, the value, what is it, 750,000, right? Is if you have a primary residence that's 750,000 or less, then there is a special procedure in probate court to pass it to heirs. If you don't have a will, if you died without a will, then there's that process. But it is a court process, so there is court. But it's a shorter timeline than a full probate. So that was supposed to be the benefit of, like, oh, people that haven't done their planning pass away with homes that are worth 750 or 750,000 or less. Well, then their kids, spouses are not going to go through a whole long 18-month long process, but they still actually have to file something in court. So it's not like this is going to happen overnight either. And let's be honest, in majority of places in which you and I are living and working right now, $750,000 is not really, there are properties, right, that are
Yeah.
that, but they're called condos. And
Yeah.
other, like, homes are generally going to be higher than that in the San Diego, Orange County, LA area.
Yeah, the median home price for a single family home in OC is 1.4 million. So that's about half of the median single family home value. So it was good intention, but it didn't rope enough folks in high value areas. So the transfer on death deed. Have you seen many of those? I did do a deal where there was a Todd involved. Have you seen many of those? Do people come in and talk to you about those?
Oh, Todd. Such an 80s name, isn't it? Todd.
It is. It
I say that my one best friend's his name's Todd. That
is.
one's
He's watching. He's angry.
the I have seen some right just out there in the universe. I have gotten calls for them. Hey, do you do them? Or more like, we want to do it this way. Like, we want to get a transfer and death deed. Do you guys do that? Uh, like with our stopgap of the joint tenancy situation, it's a band-aid. And it's a band-aid for a limited circumstance as far as I see it. And generally that is, we don't have enough time to do a trust because we're at end of life. There's an immediacy
Yeah.
aspect of it. Or I'm getting on a plane tomorrow to go on a big trip and I don't have a time to put a trust together. Maybe I do something like that. Because I don't already have my home in joint tenancy with somebody else, or I don't have it married as community property with rider survivorship. So it's a band-aid in a time. I've done one in my time that way, because the woman was literally at Cedars-Sinai in LA, going to have open heart surgery, and we got contacted by her adult daughter a couple days before. Hey, we talked to mom, and we said, the doctor said, you got to get your affairs in order just in case. And we realized she didn't have anything done, and she had her home. And so I met her at the hospital, literally in scrubs. I had to go, and she was in the ICU. She was all ready to get going. I got the call, like, we thought we had another day, and it's like, no, they moved up the surgery. It's happening this afternoon. Jumped in the car, drove up to Cedars-Sinai, get up there, like, hey, sir, she's in the ICU, so you got to jump in these scrubs. So I got to jump in these scrubs, and we go in and talk. And and I had the mobile notary with me. We didn't have time to go through a conversation about a trust or print out the documents for a trust, get all that. Is we had time to do a 3-page document, explain it, have it signed. Fortunately, she survived, and then we were able to cure that by then setting up the revocable trust and doing it the preferred way. But it was the band-aid just in case. Right?
Yeah.
So that other than that, I do not encourage it, because there's too many ways to screw it up.
Mm-hmm.
It's very regimented. There are strict rules in the statute what to do, and if you don't do it that way, then it's all for nothing.
Yeah.
So and they keep increasing these rules, these requirements over the years, because this is only good for until X year, and then we get to that year, and they say, okay, we're going to extend it another 3 years, and we're going to tack on more requirements. And so it actually becomes more difficult to deal with a transfer of death deed after a death now than it is if you had the property in a trust, as far as now you have to prove that you've notified everybody in the universe, basically, that this person died, and you have to find all the heirs and put that declaration and record that declaration and all this stuff. So it becomes the benefit is it's not helpful only in an emergency. So that's what because that situation, as difficult as it is way better than it falling into probate, not doing anything. So that's why we use an emergency. But if we have time, we're putting that in a trust instead.
That's an excellent story, and then a great example of why you need to call Kevin, set up the appointment with Kevin today. Don't wait until he has to rush in scrubs. I'm sure you look handsome in scrubs, but number one, I don't want to.
Nice. I was shocked. It was great.
I don't want to look up and see you in scrubs anywhere near me. That's I'm being honest. But no, I had a client who they used a Todd, and it was exactly as you said, where he had to notify a bunch of people, notify the world. We had to wait. I forget if it was 120 days. I think we had to wait 120 days to see if anybody mentioned anything. So this is my listing. So I'm like, okay, we'll wait the 120 days for that. And as you said, when I reached out to title, and by the way, title officers hate Todds. They do not like them. And as you said, they sent over the instructions, and based on when the Todd was signed, there were different instructions for the year that the thing was signed. He had to run through different notification time periods, etc. So yeah, agreed that it's a good emergency. Then I had another client who actually had a Todd for a property that was actually recorded, but she was still alive, so it didn't take effect. But then she ultimately sold the property. That had no effect because she was still alive.
Yeah.
So those are the four kind of shortcuts. We talked about a quitclaim deed, the Todd, just using joint tenancy, and then using a will and not a trust. So tell us the way we should be doing it, and you can go basic and deep, or as deep as you want. Like, what should we do?
I'll give you one more shortcut too.
Yeah, please.
That is a life estate.
Yes.
So that the life estate generally occurs, and we see this more with seniors, parents who they have a home that they're living in, and they want to gift it to a child or children, but they want to stay in the home, so they do it in advance and say, I'm going to give a life estate over to my child. We'll just use one for the ease of example. I'll just give my life estate to my daughter, which then effectively what that is that they're gifting it to their daughter, present value, and the daughter has a present beneficial interest, so they technically own the property. But the person has a right. The parents have a right to stay in the house. That's so they can live in the house until they die, and only then can the daughter sell the house. But the parents can't change their mind after they record that deed, and after the deed signed. But we say record the deed. By the way, it's not upon recording; it's upon signature on the deed. So
good distinction.
Once that's signed in front of a notary, the deal's done. We record it, so there's a public record of it.
Yeah.
For title companies and people that come later. So it's not lost. But once it's signed, then the parents can't take it back and say, oh, we were just kidding, or the relationship's soured or changed, or we want to sell the house. And the daughter's like, no, I want to inherit that house. You could live there, but I want to live there after you pass away. You can't sell the house. Parents don't own the house anymore. They just have a right to be there. And that's the life estate. So that's one shortcut people that's sometimes taken, because once the parents die, there's no probate because that's already been passed over to the daughter.
Yeah. And no step up in basis either, because it was already passed.
Yeah, it was already passed. So then the challenge comes, okay, well, what if we're talking about static. So we've adopted the chronology. We're going to die before our daughter. That's the belief. All parents want that and believe that. But the reality is their daughter could die. Well, what happens in that situation? Well, it doesn't revert back. This is not a joint tenancy. It doesn't revert back to the parents. The parents have, arguably, they had a right of occupancy given over to the daughter, but now the daughter hasn't done anything with that deed. It's not in a trust. They just had a life estate, and it's just sitting there. So now it goes through probate to get inherited to the daughter's heirs.
Wow.
Right? And the only hope that the parents have is that the daughter had no spouse and no kids, because then it would revert back to them. They would be their daughter's heirs, and that could fix that whole mistake. But likely the daughter has a spouse or some children, statistically, and then it's a big old mess. And then they lose the right of occupancy. So that's like one of those shortcuts. Like, it sounds really good, sounds easy, and it sounds cheap because it's not expensive to do the deed. Heck, I could do it myself, and I'll just pay the filing fees of a primary residence. Like, it's $25. So it's hey, cheap and easy, do it myself, and then there's the mess. So that's the last one that I see sometimes, and how to do it right, in the sense that a better way. And in my line of work, there are rights and wrongs. This is not the feel good or on the youth thing.
We're not all getting trophies for this.
Yeah, there's no place here. There are in the law rights and wrongs. The law can be gray, but there's some situations very black and white. And here, when it comes to real estate in California, there's a right way and a wrong way. And in my perspective, except for exceptional emergency situations. The best way and the right way is to have a trust hold title to real estate. And a trust, we'll just call it a trust. There's different types of trusts. But for right now, just the concept of a trust holding title to the real estate, that is the best way. And the reason is because the trust has a rule book that deals with all sorts of contingencies. So my 10 different scenarios out of 10, we cover all of that in the rules of the trust. So we play out life in our Monte Carlo, for our financial advisors out there, Monte Carlo scenarios where we're doing 1,000 different versions of events. That's covered in the trust, all these different contingencies. So the result that we want occurs no matter what happens in life without there being any court involvement. So that's the purpose and the benefit of a trust. And
So let's run through the Monte Carlo. You're full of great stories. Give me a few examples of incapacitation or something. I mean, exciting, awful stuff, but give me a couple good stories about what could possibly go wrong that none of us would guess.
Oh, okay. So incapacity is a big one. So another thing that's overlooked is I'm going to just not wake up one morning and die in my sleep. The reality is that there's more often than not, there's going to be a period of time in your life where you're going to be infirm before you die. And the infirmity is, the longer we live, the more likely that that's going to be cognitive in some fashion. Or cognitive doesn't mean you have a diagnosis of severe dementia, Alzheimer's, or what have you. But it's just age related. Forgetful. You're not capable of doing things and making decisions. That gets overlooked. And okay, we have joint tenants, or I have a husband and wife with community property. Okay, but you're not dead. No one died. So you need to go to Christians trying to sell your property because you need the property sold for cash to move somewhere else, or to pay for your downgrading, and you're going to use the excess profit to pay for caregivers or pay for the assisted living. But for your spouse, or your spouse trying to do that for you, but Christian can't sell the house because it requires 2 signatures and you're too infirm to sign. So that's a common one. It's like, oh shoot, we had a will. Well, guess what? The will only works when you've died. And yes, power of attorney document would be important and helpful potentially in that situation, but so would a trust. A trust includes these situations of infirmity, incapacity, as well as death. So again, it covers a lot of ground. The trust is a Swiss Army knife. It covers a lot of different scenarios, has a lot of different tools built in, all in one, right? So it's very helpful. That's one. Another outside of that deals with situations where there's a remarriage as well. So the property gets diverted from future beneficiaries because there's a new relationship. So married couple, spouse dies, the other one remarries. That's very common in the situation. And if we're talking ladies, if we're talking you dying first, guess what? Your husband's going to get remarried. Why? Because we're simple creatures and we need direction. My wife and I were talking about this week, and we had very humbling conversation about, hey, if you die, I want you to get remarried, and here's why. And in a serious, I joke a little bit in these conversations, but there's a very serious, important conversation to have with your spouse.
Well said.
But at the same time, the concern is, well, I want you to get remarried to somebody, but I don't know that dude, right?
Yeah.
I don't know that dude. She doesn't know that gal. And we're hoping that we still are going to make good choices, because we made one great choice, right? So hopefully that's not the last great choice we make in a partner. And
I hope she says the same about you.
Yeah, right. Well, honey, if you're listening, type in to Michelle. But that's the challenge is, okay, so you married the wrong person, and then that person has different designs and ulterior motives, like divorcing you. And then now that property goes somewhere else, to all of it or part of it in a divorce, or they convince your spouse to add them to a trust or title. And we see that if the trust is much more difficult, and we can plan for that to make sure that doesn't happen. But if it's joint tenants or community property right survivorship, all right, spouse died, I have it. Oh, well, I'm going to add my new partner. Not even wife, husband, they never get married. So I'm going to add them to title now.
Yeah.
Right. And then so in my case, My wife died. I remarried married poorly, or just dated poorly, and now I died. That house is supposed to go to my kids, our kids, but it doesn't because I added so and so to the title, and now it goes to them, right? And oops, I didn't really mean for that. And they always told me that they would give it to my kids afterwards, and whatever the promises are. So that scenario occurs, and that's a challenge. Then there's all sorts of scenarios when we're talking about um, children who have disabilities inherit. So now an inheritance of a property disqualifies them for a Medi-Cal benefit that they might need. But this could be severely autistic children, Down syndrome, those that are going to qualify for an SSI benefit as an adult. And then a parent dies, and a parent thought, well, I'll just add them to title so they can have a roof over their head after I die, and then a place to live. And they don't know it. They don't know that they misunderstand how the benefits work, and they die. And that house, that roof over their head, now kicks their kid off of SSI benefit, and they lose access to other resources. That we see sometimes, and with property and the quit claim deeds and things like that is triggering property tax reassessments.
Yes.
So those are challenges. Now, a trust is going to do a great job, like I said, Swiss Army knife, maneuvering around a lot of these contingencies. The property tax, the trust itself won't do that. There are other strategies that we could talk, that are a different conversation. But the point is that those are typical things I see now where the mistakes are, oh, well, I added my kid on, or these people on. Well, all you ended up doing right now is triggering property tax reassessment. Or I purchased a property with my child, and we're trying to avoid the property tax reassessment. If I, what happens? How can we do that? Purchasing it with a child makes it more difficult, actually. So with the real estate, there's a lot of pitfalls that occur when we're talking about how the mistakes people may make. The last one, though, with an inheritance is I just have a very simple estate. I have some savings, I have a house, and I have 3 kids. And when I die, I want all my kids to inherit equally, a third, a third, a third. So very simple, very simple. I just need
Seems easy,
simple, right? I just need the most simplest basic trust in the whole world. On face value, okay, beyond I don't want probate. I get it. We want to avoid that process. It all go to my kids, but I don't want them to go through that process. Okay, we'll just do a trust. But I need the most basic one you got. Like, I just don't need the power windows. I can use the roll-up windows in the car, the basic car.
As long as it's got 4 wheels, we're good to go.
4 wheels, so good to go. Well, let's walk it through. What happens after you pass away? How is that property going to go to the 3 kids? Is it going to be sold? And then the money split? That sounds easy. But again, when this is where I tell the story of my grandparents' 3 daughters.
Yeah.
I say, that's no different than in my family. Here, all it is, we avoided probate, but we didn't avoid the problem of what to do with the property. You have 3 different opinions there, what to do with the property. And the 3 of them aren't going to own the property together. Let's be honest. Legally, they are all owning the property after you die. They all have interest in it, but they're not going to go on the rest of life being co-owners of that property. So how are we going to avoid conflict? And then we talk about dynamics. And then the stories start to get interesting, right? Then we're hearing the things that they weren't thinking about. And they're telling me all the things about how the relationship isn't as rosy, and it's she's fine, but it's that husband of hers, and he's really the problem.
So wait, everybody's got a real family then? That's all it is.
The simple
plan
is not so simple, but we can design the trust to make that outcome simple.
Yeah.
Right.
So in that case, you would specify, number 1, a trustee, specify all the beneficiaries, try to keep trustee and beneficiary different people, sometimes makes it easier. And then you specify property is going to be sold within X amount of time after passing, and then it's going to be split up XYZ, correct?
That's correct, right? So you put it in clear instructions.
So nobody has to guess or make up or assume or fight over it because it's all in there. Of course, they can still fight over it.
Sometimes, Christian, it's a good idea to even name who the preferred realtor would be.
Yes.
Trust.
I will say, to pat myself on the back, I have just been named to be a trustee for a family I've worked with for a long time. We've done about 30 deals plus. So, and I know the family well, so I'm honored to be given the opportunity. So they put me in their trust as trustee, and I'll help sort it all out for them if and when.
But even if you're not, and this is just goes to show what a great job you do, how trustworthy you are, and that in and of itself is a badge of verification. But obviously, you don't have to run off and name your trusted realtor as your trustee, but you can name your trusted realtor in the trust as the realtor, because I'll be honest with you, sometimes that's what the arguments are about. Seems very petty. It's, well, no, I don't want to use her realtor or his realtor, and the house isn't. There's no listing because the beneficiaries can't agree on who the realtor is going to be, and they're going to court squabbling about these petty things.
Yeah.
In the meantime, the property's not getting sold. So if you know a good realtor, you trust them, you can put that preference in your trust. It has to be sold, and it has to be sold by Christian.
And no, thank you for bringing that up, Kevin. And that's true, because I have worked with trustees to help liquidate assets, and the trustee, it helps the trustee because the trustee wants to do the best thing for the family. So they're going to interview multiple agents and try and pick the best person if you name already the person you want. And then in some cases too, like because we specialize in tenant occupied properties, if you have a portfolio that has unique asset types, and you're going to specify an agent who knows the asset types and can navigate that process. So thank you. So let's look at some of the comments here. So All Nighter's loving this. He's listening intently. We've got Cyber LA Rudy says great show. And then All Nighter, this is All Nighter's solution in the event that you don't have a trust and somebody's incapacitated to sell the property. You go ahead and you blink twice if you're okay. that will not work, All Nighter. We need a signature. What's interesting is in California, it takes one signature to list a property, but two to sell it. So in other words, if a husband and a wife own it together, that's basically either the husband or wife could list it, but to ultimately get it sold, you need both signatures. So let's see what All Nighter has to say. I like a merit-based distribution clause myself. Keeps little Johnny from doing bad things and retaining benefits. Yeah, what do you do in that case if you got a bad kid? Like, how do you distribute?
With the bad quote unquote child, we're assuming that these situations that we're moving on the question of disinheriting, not disinheriting. We're saying, okay, we have a troubled child who we want to inherit and take care of. But because of their troubles, we don't want to leave it to them with direct access. Now, I'm not a big proponent of leaving outright distributions unless we have a very minimal estate, because there's too many liabilities out there in your life or your child's life, everybody's life. You leave someone a gift outright, it's exposed for somebody else to take it, whether that's the government, the IRS, whether it's a lawsuit, whether it's a divorcing spouse. That's always a problem. So we're looking at leaving things in trust. But if you leave your troubled child to manage their own trust, that's no different from the standpoint that they can go raid their trust. Now, we protect all the other people, but if our biggest concern is the child itself, because they're going to waste it or use it to harm themselves because they have addictive behaviors, then we don't want them having access. We want another person. So we want to leave it in a trust with somebody else being the trustee and managing it so that it's not accessed poorly by the beneficiary. If we want to encourage positive behavior, we can do that and talk through it. And that's case specific, and whether those positive reinforcements are going to work. If they, sounds nice, like one of those, again, sounds nice, sounds like it could work, but if we're not testing it in advance, then it's going to fall apart and be another statistic of another litigated case in court. We want to do that. So sometimes our best intentions of incentivizing don't work, or we're overcomplicating a situation as well. Because sometimes it's simply, we can give the trustee full discretion, and if we're choosing the right trustees, they can decide how best to distribute the funds. That might be the easiest solution. And then we might say, well, there's some other things going on. We really kind of like that pee in a cup clause. So we're going to go have the drug testing clause. I had a conversation today with a prospective client, and he's the beneficiary, and he wanted some advice on what his rights were or whatever. And he was like very concerned of, is there a pee in the cup clause in my dad's trust? So that's why I'm using it. It's not an industry term. That was his term today. There's no,
so many questions that pop into my head and so many jokes. I will let it go.
You can condition, or, hey, if you go to school, a common one, I guess, well, can we put educational milestones in the trust? If you graduate from a 4-year school or whatever derivation, you go in there, you get some, signing bonus for doing that, or access to a portion of the trust, or what have you. You can do that. Those all, again, it's all sound. We have to do beta testing. We have to do dry runs of that in the office and talking through our Monte Carlo, and that's what I'm good at, because I've seen a lot of stuff. Okay, what about this? What about that? What about this? How all this plays out, to then narrow the conditions to a point where it makes sense. So
I had an interesting one where I was working with the trustee, helping to sell the assets, and it had to be, all had to wait until the last beneficiary was 30 years old. They figured they'd just be more responsible with the funds at that point. So finally turned 30 and liquidated everything, and everybody got their money. So that right there, what you said about beta testing and Monte Carlo scenarios and running through that actually segues well into my question I always ask you is, why can't we just rely on AI to create our trust for us? And that is, I'm going to give a quick answer and then let you take over. But the quick answer is, AI doesn't know every scenario, isn't going to ask the right questions of you to create the right trust. But you step in, Kevin.
Yeah, it's AI is based on the input. So input indicates output. So if AI is not getting the right information, it's not going to give the best answer coming out. So that's one. I mean, there's hallucination still in the software, how it works, so that how it comes out. The way I look at it, you need to have a human being able to interpret what AI says. So, hey, look, AI is being used in all industries. We use AI in our practice, not as to supplant what I do or the other legal professionals in my firm do, but it's to be an assistant in a way, to make things more efficient, help organize data. That's super good for that. We use it a lot when we get a bunch of financial data, particularly with administering an estate. It helps synthesize a lot of materials, synthesize legal documents and everything. But you need a human to be able to sort through the output. And so you have to verify, is this a correct result that they're giving? Is this a correct potential clause that would work? Could we use AI to help craft a clause? Okay, well, is that actually going to work? I'm going to beta test. AI, last time I checked, we're not there yet. There aren't AI robot lawyers yet. So we don't have AI having a history of what's happening in court, in a court that's driven on results from humans. Humans being the judges, humans being the lawyers, and humans being the jury. Though in probate court, you don't always get a jury. You usually get a bench officer, but sometimes you do get a jury. And in civil court, you always get a jury unless you waive it. So these are humans making decisions, and AI does not have the ability to Monte Carlo a human condition and scenario, because there's too many variables of how a person's going to be swayed about something. They can give you the analytical result. If they were exactly followed to the T, this probably would happen in this circumstance. But working with somebody a lawyer that has the experience on both ends, both the planning side and then the court side gives you the best barometer of whether or not the plan is going to work, because you're getting that actual input historically of what other humans have done in court and what the results are. That's what attorney, and I'm not the only one, but an attorney like me, my firm, is that we have attorneys that do estate planning who also have litigation experience and actively in the past and actively handle litigation. So we see how the trust that we've done or that, not most of our trusts that we do don't end up in litigation. But again, we have the human element, some weird beneficiary does something crazy, we might be in court, how our trusts get held up against an attack in court to, all right, well, we have those issues after somebody else's trust, and now they're coming to us, the family's coming to us after there's an issue, and we're having to litigate issues and seeing how those trusts are holding up or not holding up, and how clauses are really interpreted, not interpreted, and things like that. AI does not have that capability.
Correct. And excellent point there, because when folks are litigating over the trust, that's after the people who made the trust, the original trustees, have passed away, and they can't give their input. So it's up to the document to determine what the answers are. And I could see a case too, just extrapolating, where if somebody just used AI and there's some incorrect language in there, it could maybe potentially invalidate other parts of the trust that were legitimate and right, but because you've got those holes plugged in there, it's like a boat that's sinking. So, Kevin, I can't thank you enough for giving your time tonight and all the nights you've been on here, sharing all this information, sharing your stories. So if somebody wants to either create a trust or have their trust evaluated by you for where they are in their life right now, how do they do that? How should they reach out to you?
Yeah, you see that scroll on the bottom there?
There it is.
That's the easiest way to call our office, send an email. You go on our website, there's a place on the website to submit a request as well. It goes right to that email address too. So either way, 3 ways that you can reach out and say, hey, I'm interested and want to talk. That's the best way. And then my intake team will schedule you for an appointment. Whatever one is, and they'll help decipher too. If you're not quite sure like what you need, like, hey, I have this issue, that's fine. Just reach out and say, hey, this is the issue. Our intake team is really good about helping to sift through to get you in the right appointment.
That's perfect. And I, again, do not want to see you in scrubs racing up to my bed. So I encourage you to not make that same mistake. Although he will do it based on what he shared with us tonight. Even if you need Kevin up to the very last minute, he and his team will be there. So thank you, Kevin. Really appreciate you being here. And I hope that the listeners out there and the people watching this, they appreciate the time that Kevin's putting in and doing this. And they appreciate the fact that we're having these conversations, because this is one of the only places you're getting this, where we're bringing in attorneys like Kevin. We've got personal injury attorneys, eviction attorneys. We're bringing these people in to teach you what you need to know. And look, some of this stuff isn't sexy or fun, but this is stuff you need to know, whether you've got a small growing portfolio or you got a big old portfolio. We're here to help. So make sure you reach out to Kevin with any questions, and then reach out to us as well. We have the intake team. It's me. And give me a call. If something comes up, I'll help you figure out who you need to talk to. It may not be Kevin and his team. It could be somebody else. Eviction, there's different types of attorneys. We'll help you figure that out.
Right.
So Kevin, really appreciate you. Appreciate the plug. If you want to add a real estate agent into your trust, feel free to plug me in, and Kevin can help you do that too. So, all right, go enjoy that family, and congrats on having all teenagers. That's a big thing. Good job, Kev.
Thanks, Christian. Really appreciate it.